Rick, we are in this difficulty in law because you didn't get something in writing. I understand why that's the case. The reason for it is that you've dealt with Alan in the past. Had this not been Alan, from what you tell me, I would have a contract in front of me which would say, in clear and unequivocal terms, if you cancel within 3 months, you owe the lot. Now, that's not the situation here, so I can't rely on that contract. All I have is this agreement. Alan says in law, well, I haven't cancelled, I've just postponed. What's more, I've given you 12 days' notice. 12 days in law is reasonable because you've got plenty of time, Rick, to what's called mitigate your loss. In other words, to go and find other work, and in any event, even if that's not the case, 12 days is a reasonable period of time to say, I don't need your services anymore. How am I to know that you can't get another booking, especially as you're so successful? And Alan might be right about that. And I have to tell you, he very narrowly was. I have to look at this situation and apply some common sense. In other words, what a reasonable person looking at this contract would have implied about the terms between you. And it seems to me by the narrowest margin that on any view, a successful performer like Rick could and should have expected a minimum of 14 days' notice. It seems to me by the narrowest margin, Rick, you are entitled to the full sum because you couldn't perform. It's got nothing to do with the emoji. Consequently, this court awards you £450 your full fee. Get things in writing, sir.
Do I get a deposit next time?